Test admission, item number 1.
Name, please, Mala. Mala, this is the matter. I challenge the impugn order dated 12/10 of 2012 of the Armed Forces Tribunal, Kolkata, placed at Annex 10 at page 81, Mala.
How do we get
Mala,
jurisdiction?
the fact of the case is that the petitioner was enrolled in the Indian Army on 30th March 1973.
Sir, AFT Calcutta, how are we getting jurisdiction?
Mala,
He's a resident of Baleshwar. But if the tribunal is in Calcutta, it should be there, no? Not necessarily.
where the tribunal is? AFT,
Calcutta.
Calcutta.
Yes, yes. All vast tribunal at Calcutta.
Mala,
Jurisdiction of Orissa and West Bengal.
I see, yes. All right.
Mala, the jurisdiction your lordship can have glance Annex 8 with all the matters pertaining to armed forces. Out with the West Bengal, Bihar, Orissa, Jharkhand, and Andaman Nicobar has been transferred having the jurisdiction over the AFT Calcutta regional bench.
All right. What does the impugned order do, sir?
Your lordship can have glance at Annex 8, my love, at page 35.
Right. No, that's okay. What is the impugned order? What does it do?
My lord, I challenge the impugned order that is 12th of October 2012. My lord, my sole contention and prayer before their lordship was to condone shortfall service of 3 months, 12 days was the grant of pension, my lord.
How can they condone it, sir?
My lord, that the similar provision has been held as ultra virus by the Bombay High Court in Navy, and that is being upheld by the Honorable Apex Court. And that what your lordship can have learned, that's regulation 125 of the pension regulation for the army stipulates that up to the 6 months
Which
it
page,
can
sir?
be condoned. However, in case of the voluntary retirement,
Sir,
it won't be condoned.
are you in a hurry, sir?
No, my lord.
Can you take us to that regulation 125, sir?
Yes, my lord. Condonation of a deficiency in service.
No. Which page, sir?
My lord, that is also quoted in the impugned judgment, my lord, at page 84. At page 84, your lordship can have 124. At page 84, para 4, my lord. Should I place, my lord?
Yes, please.
Upon such conditions as it may think fit or impose, a competent authority may condone interruptions of service in the case of person whose pension is sanctionable by an authority subordinate on the to the president as under. When proposed pension exceed ₹25 per month, interruption not exceeding a period of 12 months at all. When proposed pension is 25 per month or less, all interruptions, whatever durations. Condonation of a deficiency service for eligibility to service stroke reserves pension. 125, except in the case of an individual who is discharged at his own request, my lord. On that basis, it is being rejected, my lord. And though, and I was joined
Was
in
your
Indian,
case one of interruption or shortage?
that's shortfall, my lord.
This is not about shortfall, sir. Neither of these regulations talk of shortfall. They talk of interruptions.
My lord, it is, your lordship can have glanced at the para 6, my lord.
Yes.
Para 6 of the impugned order, my lord.
Yes.
We find from the annexure R2 to the counter affidavit, which the letter being number so and so, dated 29 July 2009, from EME records addressed to the applicant, it is clearly stated that the applicant had rendered 14 years, 8 months and 18 days of service, and there is no mention with regard to the deduction of any service on account of overstay of leave, as pointed out by the affidavit in opposition referred to above. Therefore, we are of the view that the EME records would have
Correct.
regularized.
This is not an interruption service, sir.
My lord,
This is not an interruption service. You
it is
sought
not
and
my
you got
lord,
your
it is the
retirement.
only shortfall of service. And
No,
that,
because of your own action.
my lord, your
You
lord,
wanted premature discharge on compassionate grounds. They agreed to it and they discharged you.
yes, my lord.
So they did not deprive you of anything. You deprived yourself of it.
Because I have shortfall only 3 months and 12 days. They have
No.
denied. Your lords can have annex 8, my lord.
Sir,
Annex,
so you're missing the point.
annex 5, my lord.
You're missing the point, sir.
At page 30, my lord.
So you do not have the habit of listening, I find.
My lord.
So let us hope that you listen to Justice Patnaik.
It's not a case of interruption. There has been premature discharge on health.
Yes,
ground.
my, my
So
lord.
therefore, the regulation doesn't apply.
My lord.
That is the point we are making.
My lord, it is not interruption. I bow down before lordship your observation. But only thing that only the shortfall of service of 3 months and 12 days is required. Because of regulation 132 says that
Sir,
total
nobody
service
can, there is no power to condone a shortfall, sir. You're making a mistake. That power is given to
yeah, like-
condone interruptions.
My lord, your lordship can have glanced at Annex 5, which they have rejected it initially. The OIC records are rejected. Should I place my lordship? Annex 5, that 29 July 2009. That is of the OIC records, my lord. As per the records held in this office, you were enrolled on 30th March 1973 and discharged on 18 December 1987 at your own request on extreme compassionate grounds after rendering 14 years, 8 months and 18 days of service, including 2 years apprentice service, whereas 15 years qualifying service is mandatory requirement to earn service pension by para 132 of the pension regulation for the Army 1961 Part 1. Further, since you were discharged from service on extreme compassionate grounds, your own request condonation of deficiency in service is also not appropriate in your case as per provisions given in para 125 of the pension regulation for the Army 1961 Part 1. Madam.
What is wrong with this, sir? What is wrong with this?
Minister, I am challenging the virus of this 125A.
That's just a
That-
virus, sir. You mean to say nobody should have any qualifying service at all for pension? Everybody should
Manas-
get pension.
Because of 125, because it is only in the case of the voluntary retirement, it is a discriminating and it is violated by Article 14, my lord. To
Very-
that effect, Honorable Bombay High Court held it is the this regulation 82 of Navy Pension Regulation 1964 is held as unconstitutional, which is being upheld by the Honorable Apex Court.
Where is that? Where is that decision? Where is the
Do you have a copy of the?
My lord, my lord.
Kindly share it.
My lord, I am relying on decision of Honorable Apex Court in the para 2.
Which paragraph?
Which is the relevant paragraph? in the
My lord,
judgment
para 2.
You're referring to.
Just pass it to, let him make additional copies. Tell him you're passing over, make additional copies. Let him make additional copies. Bring it after lunch. Tell him to pass it over and let him bring additional copies.
You kindly provide
Yes, my lord.
an additional copy of the judgment.
By the impugned order,
Passing it
my,
over.
I am
Just tell him you're
relying.
passing it over.
Should I place, my lord? Para two.
It is passed on. Kindly provide a copy,
I-
additional copy of
I
the
have provided,
judgment.
my lord, two. Only the judgment I am relying on, my lord.
Yes, yes.
You've given
Provide
only
me
one
additional copy.
You want two.
My lord, sorry, I have only two copies. That's why I have to rely on it. I will provide, my
We
lord.
will we are passing it over, sir. During the lunch hour, you make additional copies and come after lunch.
Oblige, my lord.
Ah.
May I pray, my lord, the land, may I serve a copy of this.
And also serve, make 3 copies and serve one on Mr. Padi.
Oblige, my lord.
Ah.
Well,
Oblige.
Supplementary list item number 2. Item number 2.
May I please, your lordship? I'm the petitioner itself. My lord, I pray for a week of time.
No, we are not granting any time, sir. Carry on
My
with the
lord,
matter.
my lord, the conducting advocate, my senior, is seriously ill.
What's the
A
matter
week of
about,
time.
sir?
It is a service matter, my lord.
Do you have the paper book with you, sir?
No, my lord.
So that's one of the first things you have to do, sir. We'll pass it over. Kindly get the paper book and tell us what the matter is about. Please come
My
after
lord-
lunch. Please
My
come
lord,
after lunch.
just a short address.
Please collect a copy of the paper book. Go through it. We'll help you with it, sir. All right.
Okay, my lord. Okay. Oblige.
All right.
Supplementary item number 3.
Praise the Lord. The petitioner is challenging the order passed by the appointment note 2 by annexure 10 minor
Yes.
without considering the representation filed by the petitioners by the annexure 7 directed the appointment number 3 Tahsildar to lease out the land in favor of the
Sir, this was filed in 2020.
minor. Without lease out the land, the appointment number have constructed a road beside a UP school that the petitioner has challenged that construction of road and filed a representation before the Tahsildar. And Tahsildar by the annexure 2 stay the operation of the construction of the road till the finalization of the lease. Thereafter, he has initiated 3 enclosement case against the company and fine has been recovered from the company. Thereafter, the petitioner filed a writ application before the Honorable Court, and the Honorable Court directed to file a representation before the Tahsildar, appointment number 3, to consider the matter. Before appointment number 2, minor collector matter. Petitioners has filed the representation before the appointment number 2 by the annexure 7, but without considering the representation of the petitioners, they have directed the Tahsildar to lease out, complete the lease out to the matter, lease
Where is
out
the
the land.
dispute order?
My lord,
Where is that order?
but annexure 10, my lord. Yes. $44, my lord. Last.
All right. Just say notice. Ms. Patnaik accepts notice for opposite parties. 1, 2, and 3.
My lord.
4 and 5 I had appeared, my lord. The last occasion, your lordship directed him to serve a copy. I have received it.
You have to file a counter then.
Yes, I'll file it, my lord. In fact, the collector has dealt with everything in that annexure 10.
No, you already filed or you will file?
No, I'll file, my lord. In the previous writ application, we had filed a counter affidavit.
I see. Mr. SP Mistral and Senior Counsel appearing for opposite parties 3 and 4. Sorry, 4 and 5 states that he will be filing his counter within 4 weeks. Rejoined if any. The state will also file its counter within the same time. Rejoined that too, if any. Within the next day. 12th May, sir.
Yes, my lord.
Item number 4. Supplementary list item number 4.
That appears dismissed in opposition.
Item number 5.
May I please, your lordship? My lord, am I audible, your lordship?
Yes, please.
Case relates to, your lordship, that inclusion of the judicial employee in the old provident fund rule, that is in the batch of cases your lordship has posted to 9th of April.
All right. Notice list along with.
That is WPC number 27,190 of 2021.
All right. 27190 of 2021 on 4th April.
My lord, that 9th April your lordship has
9th
posted.
April. All right. The reply any within 4 weeks rejoined. All right.
Item number 6.
Item number six.
In item number 6, I have
We pray for a passer.
All right.
Item number 7.
My lord, item number 7 is a second round of litigation. The petitioners have 32 families who have approached my lord challenging the order of the collector, wherein the petitioners are residing in plot number in Chirusai Basti, which is in plot number 371 and 364. And that area has been illegally transferred to the opposite party company, OCL, for dumping. In fact, the application of the petitioners, some of the petitioners in the present writ applications under the Forest Right Act is also pending on the very same land. And that village is totally inundated by dumping by the company.
Notice. Spatnaik.
Yes,
Your
your lordship.
accepts notice for 2, 3, 4, and 5. Mr. Party accepts notice for Union of India. Mr. Party, are you there? Mr. PK Party? So you accept notice for 1. Notice now be served on opposite party number 6 by registered speed post. Tracking report be placed in record with it.
My lord, I filed a miscase.
My lord, appearing on behalf of Mr. Paddy, my lord.
Yes.
My lord, I filed a miscase. Stoppage of dumping.
Somebody will have to do a factual determination, sir.
My lord, I have annexed the paper photographs in Annexer 8. The situation, the
Let them
village is-
verify it. Let them verify it. When was this photograph taken?
My lord, 3 months back.
So weather has changed.
That is taken time. They have taken time.
All right. Anyway, notice on the IA as well.
My lord, I may be permitted to pray something. My lord.
You don't have to permit you, sir. When you file your rejoinder, you can do all that.
My lord, let the case be taken up day after tomorrow. I can submit the photographs with the GPS location.
So they have to anyway file their replies. They can't file their replies in 2 days.
My lord, the villagers are suffering. The whole village
You have today come up. This is the first time it is coming.
My lord.
Should we allow the petition today itself, sir, without hearing anyone?
No, my lord. No.
27th April.
Item number 8.
My lord, I am audible.
Yes, please.
My lord, this is the order under 264, the commissioner, because against the assessment order, I filed the appeal, and with respect to stay, I filed the stay before the ITO, and he has passed the order basing on the relying on that circular. So my lord has already in 38914 WPC number 2021 already posted admitted and posted the matter on 7th March. That is in annexure 13, page 78.
Okay, list both these matters on 7th March. Who's Mr. Mapatra is there?
No, Mr. Chimanka is
Chimanka.
Chimanka. We say notice. Mr. Chimanka accepts notice.
Extra
List on,
copy.
7th March along with writ petition civil
38914 of 2021.
38914/2021. Is there any interim order?
Yes, my lord, interim order. That is at page 80.
Till the next date of hearing, no course of action should be taken. Against petition.
My lord, next matter is the same also. 9
Same.
also same.
All right.
Orders item number 10.
Item number 10, Lordship, I pray for a passover.
All right. Pass over.
Item number 11.
There is a defect and we are allowed to remove it.
All right, but what's it about?
My lord,
Copy note,
this is-
sir.
My lord, sir.
All right, defect be removed within one week. List there.
Item number 12. Item 12.
None appears dismissed now.
The entire batch.
Item 13.
No.
12 to 18. No, up to 18.
But he mentioned something, no? Somebody mentioned something. Maybe he also saying it's instructors. What's the matter about lectures? Okay, pass it over once.
Right.
12 to 18 passed over.
Item number 19.
19, 20, my lord, a week time, similar order, my lord, are fixed to 17th of February. Sir, and I will, a week time to remove the defect. And
17th is day after, sir.
my lord, are fixed to
Simply
similar
list day
matter, challenging the virus, man. Similar matter.
Let's simply list it day after. Simply list it day after.
I've also given the some other connected matters, my lord, number I've given, man,
All right.
on 17th, my lord.
We don't know about those, sir. Who's the council there?
My lord.
Are you the council there?
My lord.
Oh, list along with all those on 17th.
Item number 21.
Item 21, my lordship, 1 week time to remove the defects, my lordship.
19, 20 defects be removed within 1 week. That's great work. List thereafter.
Item number 22.
May I please, your lordship?
Yes.
My lord, on last occasion, your lordship directed the London State Council to take instruction under which circumstances, my lord, the alleged film was allowed to be publicly exhibited. My lord, where my lord, some obscene scenes are there. My lord,
What is your instruction? Where is the censor certificate?
No, your lordship has directed to produce the certificate, either by him or by the state council. That he has not, but I have asked him to, but I have not.
my lord, I have applied for by filing an
Both parties
application.
seek some more time to produce a censor certificate.
My lord.
List on 14th March.
Pardon me? 3rd March.
14.
My lord, I have applied for by filing an application. They are not providing me. Your lordship,
Anyway,
and
the state
directing.
council is also here, sir. State council.
My lord.
Item 23.
So
For admission, item 24.
My please, your lordship. Am I audible, ma'am?
yes, please.
Here the petitioner, after facing difficulties for years together, my lord, thereafter, before this honorable court twice, and as well as before the commissioner consultation, as well as Board of Revenue, member Board of Revenue, all the order, after passing all the order, the Tahsildar implemented under Annexure 7. The lordship kindly see Annexure 7, the impugned order, page 17 of my writ petition.
Yes.
And after implementing all the order, the Tahsildar passed to correct the record of rights in favor of the lessee. But the ROR was not corrected. Your lordship, last
You just want a time-bound direction to dispose of your mutation case. What's your grievance in the petition?
The mutation case already disposed of, but that has not yet been
My
implemented.
lord, there are 2 orders. One passed by the Director of Consultation, another by Board of Revenue. Both the orders are in favor of the private petitioner. And those 2 orders are challenged by the state government in writ petitions, and they have filed the writ petition to enforce those orders. This is the only.
So where is it? That connected matters of state government.
Everyone, all the matters are.
So let state government start first.
I think These
17097 is state government.
Yes, state of Orissa versus Salawala Jana. Annexure 1 is the.
No, 17097, 9899, 17100. So who's appearing? You are appearing, right? For the state.
I am appearing for the state.
So you can start.
Yes. I am now placing before your lordship 17099 of 2006.
All right.
Impugned order is at page 13, annexure 1. The suit land is 1.5.
Annexure
1. Page 13 of the report.
Yes. 17099.
In I am placing the second para of page 16. In consultation, the well-established principle is not to look too much technicalities, but to make an attempt to look at the substance of the case. Section 37(1) of the Act authorizes the Consultation Commissioner to call for the record from the subordinate authority relating to any of the order passed or proceeding taken and examine the same to find whether they are correct, legal and proper. These are very broad provisions given wide powers to the Consultation Commissioner to look into the order passed with proceeding taken by the subordinate authorities. So and so. So, in the facts and circumstances of the case, it cannot be said that the revision is not maintainable. In the meantime, the maps and records of the suit villages where the disputed property lies has been finally published on section 22(2) of the Act on 24/1983. Evidence show that the petitioner was sanctioned lease for an area of dismiss by an order that passed in Westland case number 8. The petitioner has produced some documents showing grant of lease and its subsequent changes effected in the ROR by accepting land revenue by the competent authority from him. It is further contended by the petitioner that he, being ignorant of law, could not take steps to place his case before the consultation authorities. Therefore, the original case record submitted by the Tahsildar be sent back to the proper quarter. There is no analysis of the case. That is the main ground I have
It's only
taken
been
in
sent
it.
back, sir. What's the big grievance about this?
Beg your pardon?
No, it's only been sent back, correct?
Yes, your lordship can send.
Yes, what do you say?
My lord, your lordship can see that when this order was not implemented, we also filed the petitioner filed revision.
That
under
is correct.
section
That is correct. That is,
38.
since it has not been implemented, he has filed the.
And there the Board of Revenue also, after hearing the matters and verifying all the documents, he passed the order. Thereafter, your lordship can see the impugned order, the Tahsildar already implemented under Annexure 7, giving all the details
May
after
I-
making all inquiry, everything.
May I suggest one
Annexure
thing,
7
your
is
lordship
the-
may direct the consultation authorities to re-examine the matter, and he will place all these facts before him that the Tahsildar has already published the ROR, corrected the ROR, and the commissioner will take it. And by analyzing all the cases put forth by both the parties.
All right. So this member board of that goes.
Yes, there are two orders, and one is by consultation.
Correct. So both these orders have to be set aside.
Yes.
After hearing counsel for both parties.
Your lordship can be just to peruse my lord. Now, here they are the litigation they are raising at this point under the OGLS Act. So consultation authority has no jurisdiction to exercise the OGLS Act, my lord. That is why if any
This point he will raise before the consultation commission.
So you raise the issue of
Yes,
jurisdiction
he
also.
will raise all these points before the council. That has also not been discussed in the impugned order, which my learned friend is raising.
The court finds that the impugned order dated 25th July 2003 passed by the Commissioner Consolidation and Settlement in Consolidation Review Case number 61 of 2003 and the subsequent order dated 14/2/2005, the member Board of Revenue in Consolidation Case number 4 of 2004 do not deal with the principal ground of the petitioner regarding lack of jurisdiction. On that short ground, the impugned orders aforementioned impugned orders is set aside and the matter is remanded to the Commissioner Consolidation Settlement. And the matter bracket consolidation review case number 61 of 2003 bracket is revived before the Commissioner Consolidation Settlement Orissa, where it will be listed for directions on 21st March 2022. All the contentions of the parties are left open to be urged before the Commissioner Consolidation Settlement, who will pass a fresh order after hearing them, uninfluenced by the earlier order that has been set aside.
By the end of April.
Not later than 2nd May 2022. The order should be made available to the parties not later than 9th May 2022. The court clarifies it is not expressed any. No, that you take off. If aggrieved, it will be open to the parties to seek appropriate remedies in accordance with law. The petition is disposed of.
My lord, in other cases, only case number will be changed.
Correct.
And in view of the disposal of all these writ petitions filed by the state, I think the writ petition filed by the private opposite parties, they have become infructuous or settled.
Your Lordship, can you see everything I have filed my written submission? They have only pointed out about the forestry land. The forest land was not came into force at the time.
You just dictated the order.
So the litigation, the petitioner facing since long, my lord, the litigation and
this will be the last
number of cases.
I think this will be the last phase of his litigation. It will be disposed of by the end of April.
Correct.
Item number 25.
May I please, Your Lordship?
Yes, please.
Here is a case. Land acquisition collector by Annexer 1 acquired some land for the Mahanadi coalfields. Petitioner is a land trustee. He belongs to village.
1 minute. So who appears for MCL?
I am. Here the fact is, Miller, in village Kalayakati, 3 patches of land was acquired. And out of 3, Miller, the other 2 persons, those that is the land adjacent to each my plot, and the land was acquired less than my land. They have given employment in the Mahanadi coalfield. And though, Miller, Your Lordship kindly see Annexer 4, a specific instructions were given by a committee, even where the zonal officer of the MCL, page 15, Miller, Annexer 4.
Yes.
Where the committee consists of Miller, zonal officer, MCL, and other officers, they have recommended, that is last para, Miller. Your Lordship, that is the page 15, last para, employment to land trustees of MCL TTPS. Thereafter, Miller, Mahanadi coalfield has not taken any steps. Again, another committee, district committee, Miller, Annexer 6, page 20, dated 22/6/2004. Again, that zonal officer, MCL, and all the persons, and the objection raised by the Mahanadi coalfield was taken into account. They said the government guidelines is not applicable because the land acquired.
Mr. Rao will continue after lunch. We'll continue after lunch.
to mention, in item number 45, your lordship has closed the hearing, weekly list. We'll file a written note. I pray for 2 days time.
Weekly list 45, what did we say?
That Mr. Das was arguing before your lordship and your lordship has closed the hearing and 45.
Sir, we will pass the order today itself.
Only day after tomorrow I will file it.
All right, we'll reserve the orders.
With day after tomorrow we'll file it. Another mention before lordship.
I make pardon to.
Item number 6, the lordship has that video clips I have brought. That was passed over. Mr. Misra is here. Can your lordship take up now?
Okay.
Item 6. Officer is the video clips I have handed over.
My lord, with your lordship's kind permission, in fact, I also got the video clips. I wanted to send it through mail, but I was told by my associate had contacted by the courtmaster that I should have produced it in the shape of a pen drive, which I could not do immediately. But if I am permitted to share, I can share it. I hope I will be able to share it. So I am not an expert. I will be able to share it, my lord. My only contention in this case, if your lordship takes up this case now, because my learned senior appearing for the state says that he has some personal difficulty. The only thing on the basis of which your lordship was pleased to direct production of video clip is page 47 of the brief, where the collector says by the side of the boundary wall, because they have made construction over a gochar land by making alienation, but those things are no more relevant in the sense, maybe the challenge to all those things will be very difficult. But the only grievance was that 5 villagers of 5 villages, they are being deprived of communication to their agricultural land. And that is how your lordship wanted that in proof of that, video clips should be produced by the respective parties. Now, my lord, if I am allowed, my lord, to share screen, I'll just demonstrate. By the side of the wall, there exists government land, and thereafter the agricultural land are there. But there is no road exists. The collector, only on the basis of a report of the Tahsildar, had decided it on paper without making a spot inquiry. And in fact, I have stated in the writ petition that despite the direction of the reasonable court, though I was given 2 dates, thereafter no date was given and I was not heard. Even leaving aside that hearing part of it, if your lordship will see the video, there exists, my lord, space, but they have a road. Now they are asking us to go through the national highway and covering 5 kilometers to access to their
No. That is the point. That is the point.
And not only that, the road which was immediately leading to the Mr. Mishra, you should take a pause. Only then I will be able to say something.
I'm sorry.
He has handed over a video. We'll play that video first, and then we will play you can share yours. Okay? And then I'll hear submissions after that.
My lord.
Amiable pardon to mention, my lord.
Not yet, sir. Kindly wait. Kindly make it a big screen.
Yes. This is grid and the side is the hospital. It house is disputed challenge. This is the road connecting to the hospital.
So where are the petitioners' villages?
This is a connection from the main road. Actually, I'm sorry.
How long is this?
No.
11 minutes.
This is connecting to that.
No, we can't be watching for 11 minutes. Aage chalna.
Next. This is another alternative road.
No, I'm not getting an idea of where the petitioner's fields are. Or
I have a video.
My lord, may I submit one thing? The whole dispute is we have several alternative roads, but they want that they should get approach through the hospital. Just inside the hospital, a road should be carved out and they should be allowed to go, which we are not in a position to do.
in this map, where are you?
And the purpose is they will do it plotting purpose and they will sell it.
No, here there is a medical building in the middle.
Yes. This yellow line, that they. That is the connecting road from NH to medical.
That yellow line. No, where are their villages?
Their
I'm not.
village is the right hand side. Back side of medical, agricultural land.
So there are no roads connecting to their land.
Yeah, that is the your lordship is that orange color road that is there, and several other connections are. That is a length is more. Then this is the direct approach, but they have to go inside the hospital.
All right. Yes, Mr. Mishra, you can share yours. I'll just allow him to share.
I'll just clarify one thing.
Ah.
Before my just sharing the video, I'll just clarify one thing. The villagers never wants that they should go inside the hospital. Let me just humbly clarify. Because page 47, the collector has observed that since there is a road exists at the northern side of the boundary wall of the hospital itself, they can have access. Now, I'll show from the video, though there is a space exists, they have not made a road. As your lordship was pleased to notice, the road in which they are asking us to go is around 5 kilometers and we have to travel through the national highway. That also video I am having, I'll show to your lordship. I think I have been allowed to share screen. No, it is disabled. My lord, your lordship, may I ask the computer professional to allow me to share the screen. I'll just show to your lordship the screen. Video.
Now it's allowed, sir.
My
North side is Arodi Road. What I'm getting
just
the instruction, that is the Arodi Road and that is also.
Your lordship will see now. This video which I am playing now, this video, my lord, your lordship will kindly see, this is the boundary wall of the hospital. By the side, your lordship may kindly notice there is space and thereafter the agricultural land. Your lordship wanted to know the agricultural land. Your lordship sees the agricultural land, and by the side of this wall, your lordship sees that government land is there. That is what the collector has
No, but
observed.
we can't compel them to do that kind of a thing, Mr. Mishra.
That is what the collector has said, that we have access. Then your lordship may kindly see the next video. Your lordship wanted a proper view. This is the hospital boundary wall. Your lordship sees. Thereafter, the agricultural land is there, and by the side of that hospital wall, the road is there. My lord,
It's inevitable. There'll be sometimes some extra distance will have to be traveled, but that cannot be helped.
Here, your lordship may see
the whole purpose is, your lordship may kindly, they want to convert this agricultural land to homestead and do it for business purpose.
Colony.
And they want a small, less length approach road. There are approach road from all the sides. That is my instruction.
Small clips of few seconds of videos. This is one of the videos.
You are showing the video of a particular place, not showing the entire thing.
May I request my learned senior just to permit?
It's okay.
So that I can show to your lordship. These are the agricultural land your lordship can see. This is the boundary wall of the hospital your lordship can see. And by the side of that is what the collector says, that by the side of the boundary wall, there exists a road for access. This is the observation of the collector at page 47. I am not claiming anything else what they have said to allow. I am not saying that I should be allowed something more than what they have said. This is what they have said, your lordship. Then
My
your
lord.
See another video. Your lordship wanted to know that what is the travel distance. It is more than 5 kilometers. This is
That's okay, sir.
So what?
Beyond a point, as
This
a
one,
height
your
of-
lordship may
This is
kindly
less
see.
than 2 kilometers. My instruction
Let me
is
clarify.
less than 2 kilometers.
This one, there is a gate. The gate, your lordship will see this blue gate. This is where they have blocked the access. So we cannot go through this road. We have no grievance also. This is what I wanted to show from this small video clip. The blue gate is there, they have blocked. Now the fourth video, your lordship will see. This is the where they have given the access. This is the road. Your lordship may kindly see. We have to connect to the national highway and go through the national highway. Now the collector says there is an access by the side of the boundary wall. I only pray that access may be made a road so that we can access. Because there is a land. I'm not saying that we should move through the hospital premises. I'm never saying that. Your lordship may kindly see. Now we have to connect the national highway. Then from there we have to go. Here your lordship may kindly see. That's how highway, the trucks and everything are going. Here we have to connect and reach to a distance of 5 kilometers. This is where we have to connect to the national highway.
These are all connecting roads. He is saying that
Yes.
this length of this road is more than
Now, my lord,
what
these
he is
are all four
interested to take.
I'm not saying anything else. Your lordship, I am only saying whatever the collector has observed in page 47 may kindly be implemented. I'm not saying anything else. Page 47, may I just with your lordship's kind permission place it, my lord. Only 2, 4, 5 lines, my lord.
Yes.
May your lordship will see. Your lordship will kindly see page 47. Gone through the enquiry report of the Tahsildar Bhadra, he stated that the district headquarter hospital is constructed over plot number so and so of Kisam Patita, area so and so, under Khata number so and so. After construction of the DHQ hospital building, the hospital authority have acquired the land and constructed boundary wall to prevent trespassing of public through the medical campus. Thereafter, it is relevant. At present, the recorded tenants of the villagers are using the road adjacent to the DHS boundary wall for northern, southern, western side of DHS. There is no problem to approach the agricultural land by the farmers, inhabitants of that locality. I have shown to your lordship by the side of the boundary wall, though there exists space, there is no road. So they should make it a road. That much I am praying for, nothing beyond that. The collector says there exists a space. That is the observation of the collector.
All right. Pursuant to the order passed on the previous occasion, video clips have been played in the court, both by Mr. Devakanta Mohanty as instructed by under the instruction
Tahsildar Bhadra.
Tahsildar Bhadrak. Mr. Samir Mishra has also shared video clips taken by the petitioners, by the petitioner. Paragraph. As regards access of the villagers is concerned, having watched the video clips, the court is satisfied that the present access available to the villagers appears adequate. Stop. Although there may be some inconvenience because of an extra distance to be traveled, the court cannot possibly give a direction to the collector as to where an extra access should be given to the villagers and whether it should be through the land adjacent to the hospital or not. These decisions are best left to the local administration to take, since they have a better assessment of the ground situation. Full stop. The court is not persuaded that it should interfere in the matter. The petition is dismissed.
Maybe pardon my lord. Item number 24. Your lordship already reminded the matter to the consultation commissioner, even if all the orders in favor of the petitioner. But your lordship kindly till disposal by the consultation commissioner, the petitioner should be protected.
Oh, interim order was there. That should be extended till.
Yeah,
Yes.
the interim
Yes.
order will stand extended till the consolidation commissioner
Yes, ma'am.
Oblige, ma'am.
passes the fresh order.
Item number 4, ma'am.
4 is over, no?
My 10 was next.
You can file an application, sir. That matter is over. Item 4 is over.
Item 23, my lord.
Well, item 4, I will file a restoration petition, my lord. Restoration.
Whatever is passed over will be called at the end of the board, sir.
Okay.
Item number 25 now. Supplement.
In this matter, Miller, Land Acquisition Officer Sambalpur acquired land for the Mahanadi coalfields in Brajrajnagar area, Miller. A patch of land in village Kalikani was acquired and three patches, Miller, connected to adjacent to each other. There, Miller, the committee has given recommendation to give the employment to one of the member of the family. That the two persons were given, and petitioner was not given on the ground, though it was recommended twice by Annexure 4, page 15. Miller, last paragraph, I am just placing page 15, Annexure 4.
Yes.
The inquiry reports in respect of 11 number of petitioners were put up before the subcommittee. Now, after examination of the records produced by the zone officer MCL, a list of 3 persons were found eligible for jobs. The selection is enclosed herewith for Annexure 1. Further, 5 numbers of the cases were not found eligible, that is lost. Further steps are to be taken by the MCL authority in the matter of the employment to the selected candidates and to report complaints. Next page, Miller. My name was there, page 17. This was not implemented. Mahanadi Coalfield take an objection that was placed before the district level committee by Annexure 6, page 20. The objection was taken into consideration at page 21 and rejected on the ground. Your Lordship, kindly see.
Less than 1/3 of the total holding. Extent.
Page 21, review of the old cases. Review cases of land use is recommended either by the rehabilitation subcommittee but not considered by the MCL. The committee took up review of the cases and land use and found the following land use fit for employment MCL. An area of 9.20 out of the total area of 7.940 appertaining to the Khata number 205, Brajrajnagar TU number 2, Kalikani, recorded in the name of the Balmukund Das, has been acquired by Land Acquisition Act. Though the proposal for providing employment of Sri Sunil Kumar Das, grandson of the recorded landowner, Balmukund Das, was specifically recommended by the Rehabilitation Subcommittee on 2196, that is Annexure 4. The MCL did not exceed the recommendation on the ground that the extent of land acquired is less than 1/3 of the total land holding, which is like this. Because that was taken into account and it was rejected. It is observed that heirs of the landowners who parted with the less quantum of the land, Srivatsu Das and Madhusudan Das, have been given service, but their landowner Sri Balmukund Das, who parted more quantum of land, has not been given the same benefit, though their merits consideration for the rehabilitation, it is observed to be followed. The committee held that since above guidelines came into force in 1989 and land was acquired in the year 87, it is fit for employment and therefore recommended. So they said the guidelines are not applicable here because the land was acquired in 87, guidelines came in 89. In spite of that, Miller, no action was taken and matter a representation given to the governor that was forwarded to the RDC. RDC was directed to inquire into the matter and give suggestion. Annexure 7, page 39.
Yes.
With reference to the correspondence on the subject cited above, I am directed to say that a copy of the petition has been received from the Governor's Secretariat the RDC ND has been pleaded to pass orders to examine the claim for the redressal. This is the order. On going through the contents of the petition, vis-a-vis the available office records, it is found that the claim of the petitioner merits consideration. The petitioner has given 2 instances where the nominee of the other land trustees were being appointed by the MCL. Though the
Anyway, so this is a recommendation of the RDC.
recommendation is same, Lord, about the MCL, next 3 lines. Authority is not at all liberty to follow the different principles similar cases. Besides, it is seen from the proceedings, the REC meeting, that 2-225, that is Annexure 6, that the case of the petitioner has been discussed in detail and the committee recommended it to be fit case for employment after due deliberation of the principles of guidelines from the date of the acquisition. Hence, the committee overruled the ground basing on which MCL did not exceed to the prior recommendation of the rehabilitation committee. So the objection taken by the MCL was overruled and directed to give the appointment. In spite of that, when they have not come, I have filed the writ application. Now, Your Lordship, kindly see the counter by the state. They say yes, it should be that guidelines is not applicable because the land acquired in 87 and the guidelines came 89, that is not applicable. Your Lordship, kindly see page para 7. Para 7 Millard at page 42. Yes. Last para. That in reply to the averments made in para 8 of the writ application, it is a fact that MCL authority did not consider the case of the petitioner on the plea that the extent land acquired is less than 1/3 of the total holding, acres 7.94 decimal of agricultural land as per government uniform guidelines for rehabilitation on 21/2/189. It is pertinent to mention, however, that the agricultural land of the under section 4(1) notification of the Act is 25/6/87, which was prior to the implementation of the government guidelines. And further elaborated in next para, last 4 lines. The committee also opined that as the petitioner's grandfather land was notified in the year 87, dated 25/6/87, which was prior to the enactment of the government guidelines, dated 2/1/89, and found to be fit for employment. Government also says to give employment. Now the stand of the MCL Miller, because the guideline where it was held, if the land 1/3 of the land is acquired, only they will get. And in the counter and government guidelines who formed the guidelines, they say it is not applicable. Your Lordship, kindly see the counter. It is also counter of the MCL Miller. They have made a wrong statement also that Annexure 6, by Annexure 6, the recommendation was rejected. Page 76. Page 76, running page 76, counter Miller, internal page 5.
Yes.
The stand of the MCL Miller. Para 7, that in reply to the amendments made in paragraph 10 of the writ application, is humbly submitted that MCL is not aware of Annexure 3, which is representation dated 25/3/95, and ground further that petitioner addressed to OP number 5, Special Land Acquisition Officer, in which grandfather of the petitioner has tried to get employment for the petitioner, comparing with other land uses of the same locality, Kalekot, Brajranagar town. It is he had reiterated that employment of land usage is governed by the rehabilitation guidelines formulated by the government of Orissa, which came into force in the year 1988, followed by 89. The violation of the guidelines by the rehabilitation committee formulated by the government does not confer any right to the petitioner to seek employment cited in violation. Hence, there is no merit in this. Guidelines, the government says the guidelines is not applicable. In spite of repeated direction to the MCL, relying on the guidelines, they say I am not entitled. Further, Millard, they have given a wrong statement. Your Lordship last. It is further submitted that said recommendation of the rehabilitation subcommittee meeting held on 2/1/96 was reviewed by the rehabilitation committee on 22/6/2004 and was rejected. Your Lordship, Annexure 6, they have recommended. Now, because that ground, the rehabilitation committee rejected is not entitled. That is a false statement. Rather, the recommendation is that they give appointment. Your Lordship, kindly see Annexure 6, which I have placed, that the government guidelines is not applicable. Annexure 6, page 21. That page 21. Rather, the objection taken by the MCL was overruled and direct and said the guidelines is not applicable and petitioner is entitled for employment. This is the Annexure 6 and the statement made by the MCL in page 5, running page 76, that has been rejected. That is falsely stated to mislead the court.
Yes.
And Millard,
Your MCL.
Yes, ma'am.
Yes. So you maintain that the land that he lost was not less than 1/3.
Yes, ma'am.
That's the main reason why he's not entitled.
My lord, according to, as per the petitioner, there is no guideline at all. Then what is the meaning of subcommittee recommendation? And what is the meaning of that 2 persons who have got the service? If there is no recommendation at all. My lord, there is a guideline. Under the guideline, this committee is formed and this committee has recommended 2 persons. They have got and he has not got. Okay. And that is the only guideline. There is no other guideline. Let them say that is there any other guideline? Then what is the meaning of committee to recommend? There is no committee. Only guideline. That is in Annexure C and D of the Annexure. There is a 87 guideline. There is a 89 modified guideline. There is 2 guidelines, my lord, by which they will get a compensatory compensation. Then there is no guideline. Then how could you get compensatory compensation?
Yes.
My lord, your lordship, I have given a small note, my lord.
Yes, you got that.
My lord, first, there is no dispute regarding the annexures or, my lord, your lordship, see paragraph, annexure, first, your lordship, see annexure C and D of the guideline. That is in my encounter, annexure C and D. This is one is 87 guideline.
Yes.
Your lordship, say like this, there is a column compensatory guideline. 4.
Yes.
Employment. For employment. They, in 87, the case one. My lord, in 87 guideline, the case of the families, that is your lordship C. 4C. The case of families living list only the homestead can one member from each family can be provided with a job. My lord, in the 89 guideline, your lordship see annexure. In 89 guideline, my lord, yourself, that's see yourself, that is a column 4, employment. Employment is stated in case of families having lost only homestead land or the total agriculture holding, one member from each family shall be provided with employment. My lord, previous only homestead, here either previous homestead or 1/3 of the total agriculture land. And it is admitted case that 1/3 of the agricultural land was not acquired. That first question. My lord, it is not come within the guideline. That is the only guideline covers this. And these 2 persons who they according to them, 2 persons have got, that is only with this 89 guideline. They have sent it. And my lord, another thing, they say, the total land acquired 9.2. Second paragraph, I am reading, there is a small note. A bare reading of UG guideline 89 and modified guideline 89, it is clear that petitioner is not covered for employment in terms of category ABCD in both the guidelines, in which the recommendations are not accepted. The reason for recommendation equally erroneous was suggesting that the heir of landowner, that is quoted from that, heir from landowner having lost less land and had been provided service from same locality, but petitioner has not given same benefit in spite of more land is acquired. At the land is acquired in 87. He is covered in 89 guideline. The total 9.20 out of total 7.940 acquired, it is not 1/3 of the holding, not covered under 89 guideline. It is only submitted that benefit extended to some person in an irregular or illegal manner cannot be claimed by the petitioner. The concept of equality is provided positive concept which cannot be enforced in a negative manner. In a similar case reported in my lord, I have given the decision 274 SC from Prem Kumar Sharma. It is held that wrong decision by the authority doesn't give right to enforce the wrong order or claim parity or equality. Hence, the no consideration. Your lordship says that that's a total cover. That is another another land acquired under SCCL. This is the same thing happened, my lord. The Honorable Supreme Court has stated this, but this is my only content, sir.
Yes, Mr.
Millard, I have given one decision, Millard, and other decision, Millard, that the land fund are argued. This is Supreme Court decision, Millard. That is our own High Court decision. There, Millard, own High Court decision that 2006 Volume 1 OLR 812. Earlier I have given that Subodh Chandra Devnath. There, Millard, 2 persons appointed on the same date. And they are also represented on the same day. but they were not given. They were not regularized. One challenges the matter in the
service law, regularization.
there, Millard, I will say that how it is applicable, I will say. And first decision that 2006-12 alert 612. One challenge in the Hyderabad tribunal. The direction was given to seniority was given regularized. And another case was filed before the Cuttack tribunal that was rejected. And the matter has come to the High Court. Your Lordship, kindly see at paragraph 7. At page 816. And earlier, Millard, the Lordship has paragraph 6. It is the contention which I made, Millard, page 814. First I will place paragraph 6, thereafter para 7.
Yes, sir. Please carry on.
There is a patent of decisions of the Honorable High Court to the effect that in case two equals are treated differently, it cannot be said that the action is discriminatory and violative of fundamental rights. But if two equals are treated differently, there is no doubt that the action of the state would be discriminatory and violative of Article 14(16) of the Constitution of India. In one such decision, in the case of Prabodh Dharma versus State of Uttar Pradesh and others, 1985 Supreme Court 1687, it has been held that Article 14 of the
So don't please
Constitution-
read, kindly don't read this whole thing like this, sir.
No, next
You can skip over all that, just the main point you can make.
Yes,
Don't again read errand of the full thing.
Para 7, your last para 7. After discussing the decisions,
Yes, yes.
in the
So
instance
they agree that he has been discriminated against. You don't have to read the whole thing. That's all right, sir. You don't have to read the whole thing. That's only about service law regularization.
And here, Millard, the second decision that I have placed in Millard,
Yes,
the 2008 volume 2 Supreme Court cases.
correct. Maharaj Krishan Bhatt.
Proposition of law, plus system I am placing and benefit of similarly situated. Proposition of law except a wrong decision.
Correct.
Is one case could not be extended to others.
All
That's
right.
my land friend has cited.
All right.
Here is a case, Millard. In Jammu and Kashmir, a representation was made to the Chief Minister for regularization as a sub-inspector. That was, DG was called recommendation. Out of 6 persons, 1 person was regularized. That was challenged in the High Court. Thereafter, it was division bench. Thereafter, Honorable Supreme Court. That was confirmed. The other persons, they filed a representation. That was rejected. And the single judge has accepted, say it is applicable. Division bench, Millard, has said dismissed the appeal. And Supreme Court, it has come to the Supreme Court has confirmed. And the rest of the persons, once they filed, Millard, your Lordship kindly see, that is a para 14 and para 18, 2 paras I am placing. The Land Council also submitted that the impugned action was clearly violative of Article 14(16) of the Constitution. It was submitted that initially such violation has been committed by the state authorities, the Director General of Police and the state government in as much as the cases, all the constables were similar and representations were made Dar, who was appointed PSI, and the case of other similarly situated applicants rejected. Millard, that other adversely affected constable approach which I have stated, ultimately paragraph 18, your Lordship kindly see. Having heard the land council for the parties and having gone through the facts and circumstances of the case, in our opinion, the appeals deserve to be allowed. Firstly, representations were made by several constables requesting the authority to appoint them to the post of PSI. The office of the Honorable Chief Minister sent all the application to the Director General Police, who recommended only one name, Hajatullah Dhar. It is stated that said constable was having postgraduate qualification, and the Director General thought it proper to recommend the name for appointment of PSI in relaxation of regulation. Even it is assumed the educational qualification was a relevant consideration. At the most, it would go to the so that appointment of Hajatullah Dar was proper. Nothing more than that. But one, so, Milad, to sum up, the submission, Milad. State counter, Milad, annexer A, Milad. State counter recommendation on the basis of the recommendation made by the committee, 2 persons are given the appointment. There is no disputed facts in the case. Same land adjacent to each other. And now on the same recommendation, Milad, subsequently your lordship has made representation that was taken into account, and the state government and the committee, they said these guidelines are not applicable. If the guidelines are not applicable, Milad, the stand of the MCL, who is the on behalf of the whom the land was acquired. My respectful submission to sum up my submission, I have pointed 90 recommendation was made. Those 2 persons, they have got it. There is no disputed facts. Same accusation, land is side by side. There, my land is more than the land which was reacquired by them. That is also factually there is no, and the state who is acquired this land for the Mahasatish goldfields. This is a state guideline, state government guideline, not only for this, it is for Denkanal and others also. It is general guidelines, which has came into force in 89.
Yes.
That's why the government counter and RDC, they have specifically stated these guidelines will come prospectively, these are not applicable.
Right.
If these guidelines are not applicable, Milad,
yes,
the stand of the MCL, for whom the land was acquired by the government, and the government himself says that these guidelines is not applicable, and relying on the same guideline, he says is not entitled, though on the basis of same land acquisition, 2 persons are given, I was not given. That is, Milad, he is also in the representation, as stated, that is a discrimination between the same. And I have cited these 2 decisions, Milad, and this is
orders, sir.
My lord, if there is 1 minute, my lord. If there is a no guideline, my lord, then how this land is in under the land acquisition, there is no question of employment. Employment is only provided in guideline. That is issued by the state government. Your lordship see the employment in under the employment ABCD. Your lordship have said these two guidelines are not provided, and two actually. Then what is the committee to provide?
So normally in a case, petitioner will argue, respondent will reply, petitioner will have a rejoinder. Now respondent will again argue. After you argue, he will again argue.
Only my lord.
After he argues, sir, you will again argue.
No, my lord. Only I says that he has said this stated some.
You take it from me. After you finish arguing, he's going to start arguing now. You argue now. You argue.
No, my lord. If your lordship does.
No. If you argue, he will argue. You argue now. You argue.
My lord, the decision, whatever he has cited, my lord, all these decisions are applicable.
Yes.
This is regularization. Mostly with a concept. But here is a concept. This is negatively he wants that somebody he got and I will get. Somebody got it illegally or some favor is given to somebody else. Once it is detected and it must be given to me, and that is the equality. I have given that decision directly, my lord. That is also acquired land in through under the SCACL, and this is the decision. I'm sorry, my lord.
Over. All right.
Supplementary list item number 26.
Item number 26, the petitioner has no instruction.
All right. Counsel petitioner states that he has no instruction.
Item number 27.
Memo is taken on record. Disposed of in terms thereof.
Item number 28.
My lord, item number 28, there is no instruction.
All right.
But I am appearing for the opposite part number 3, my lord.
All right.
Item 29.
None appeals dismissed for non-prosecution.
Notice period.
Item number 30.
Permit to withdraw, my lord. All right. Counsel petitioner seeks leave to withdraw.
30, my lord, I appear for the corporation OP number 2.
All right.
Item number 31.
None appeals dismissed for non-prosecution.
Item number 30.
All right.
32.
None appeals dismissed for non-prosecution.
Item number 33.
None appeals dismissed for non-prosecution.
Item number 34.
May I please, Lordship. And here is a public interest litigation. As per Rule 8 of the Odisha High Court PIL rules, Lord, under Annexure 12, I have given the notice to the collector and also the Lord, with regard to his consultation matter. Irregularities has been committed by the officer, consultation officer, Amin and Pian, and FIR was lodged and charge sheet has been submitted against them. But after receipt of this PIL notice, Lord, under Annexure 14 and 15, the Board of Revenue has directed to inquire into the matter and submit report for decision. Lord, but in the counter, they have not stated about this, whether the report has been submitted and any decision has been made. So Lordship may dispose of with direction that pursuant to Annexure 14 and 15, the Board of Revenue will decide the matter with regard to my PIL application.
Who's for the state?
Representing for the state, Your Lordship. Thorough inquiry has been done, Your Lordship. Records have been corrected, all the defects have been removed, and they have also been published, Your Lordship.
But in this regard, they have not stated anything in the counter. With regard
It
to
is
Annexure
written in
14,
para
this is
7. Para 7.
letter dated 8/5/15 and Lord, another is 12/6/2015, Annexure 15. Both the letters, there is a direction to the Deputy Director and
Please see para 7. Board of Revenue has also inquired into the matter.
No,
And in the inquiry conducted by the board officials, para 7, Your Lordship, internal page 3 of the counter, second paragraph from the last, bottom, Your Lordship. In the inquiry conducted by the board officials, substantial irregularities were noticed in respect of village Chandol only. The defects noticed in respect of village Danpur and Kesharpur were more technical in nature, like improper maintenance of case register, wrong reporting in monthly returns, etc. The irregularities noticed in respect of village Chandol were thoroughly verified with reference to the connected case record, and the defects were rectified, and the records were prepared according to the instructions contained in the inquiry report of the Deputy Secretary. It may be mentioned that as many as 1458 number of cases were registered under section 151 village Chandol, where only defects were noticed only in 17 cases, Your Lordship. They have already been removed, and the final ROR has also been
But
published.
this is pursuant to letter dated 22/2013. It is prior order. Lordship, page 13 in the paragraph where my friend has read just before
It was
that.
by the Board of Revenue.
Yes, but this is letter 14, annexure 14 and 15. This is in the May 15 and June 15. Both the letters, Your Lordship, will find directing the Deputy Director to conduct an inquiry and submit report for compliance of the my application to decide the application. They have not submitted. They are silent with regard to this annexure 14 and 15, where categorically a Board of Revenue has directed the Deputy Director. This relates to Lordship will find from 2015. My friend has shown with regard to 2013. Subsequent also it has found
that inquiry would have taken some time, and then the follow-up would have taken time, Your Lordship. In
My
between there, I
submission
guess
is-
the notice is there, your representations are there.
But my submission is annexure 14 and 15 has not been complied with till date, because they are in the counter, they are silent. They have not stated anything with these two letters.
No, but all of this is in relation to these 3 villages only.
Yes, 3 villages, they have lot of irregularities have been committed. Fraud has been committed. The 3 officers, and Lord, they have issued ROR in favor of dead persons. And there are a lot of irregularities with regard to plot number and Lord area.
For this counter affidavit, when was this counter affidavit filed?
2016 has been filed, after filing of the writ filed, but they have not stated.
1 minute, please. You have not filed any rejoinder to this.
No, I have not filed rejoinder.
So then they
My
say that
my
around-
submission
March
is
of
that.
1 minute, sir. 1 minute. When they say that out of 1458 cases, defects were noticed only in 17 cases, are you disputing that? You're not?
Yes, Lord. That has not been decided as yet.
No, you're not disputing it, sir.
Day
You've
before
not filed
yesterday, I
any
obtained
rejoinder.
instruction, Lord. The petitioner aged about his 87 years.
Whatever
Day
it
before
is.
yesterday, he instructed me that my land has not been corrected as yet.
That
The
is
petition
different. He
number
can always
2.
go and get it corrected. Doesn't mean it's a fraud.
No, yes, Lord, it is admitted. In the counter, they have admitted that there is irregularities been committed.
Not in vis-a-vis this particular petitioners, and then it's not a PIL then.
No, Lord, I'm representing for 3 villages. All the petitioners are
You
represented
said
for
your
the 3
petitioner
villages.
is some 87
In 3
years old, and
villages,
his land is
there has
not, now
been.
you're saying it's all villages.
Not my submission is these 2 letters may be complied with, and my application under Rule 8 that may be decided in accordance with law.
Yes.
Lakshmi, they direct that.
The villages have
If-
also
if-
received
if
their
they have
final
already
RORs
decided-
without any objection. They have not even put in any objections, Your Lordship.
Yes,
After
lot of
the
objection.
publication of the
Pursuant to
ROR.
objection,
That was before. They've scrutinized everything, Your Lordship.
earlier there was
Around
objection.
1,458 number of cases were there, Your Lordship, which were registered, out of which they found that irregularities were relating to only 17, and they have corrected the RORs and all other technical things that was related to the other 2 villages also, Your Lordship. That also they have rectified, Your Lordship. And the counter was filed on 24/10/2016, Your Lordship.
But I'm saying that there is silent. We are not said anything about the
We've taken
2
care of all your
Board of Revenue letters.
all the
The higher authorities are
issues raised there,
directed.
Your Lordship.
This is relating to their 2011 and 13. That report. Subsequently, they have not submitted any report after this letter of the government, the Board of Revenue, Odisha Cuttack.
In the counter affidavit filed on behalf of the opposite parties more than 5 years ago, on 20th October 2016, they stated that while irregularities were noticed, pursuant to the inquiry conducted by the ACO bracket Tech and ACO bracket Judicial of the Board of Revenue, as well as by the Deputy Secretary Board of Revenue, substantial irregularities were noticed in respect of village Chandol only. The defects noticed in respect of the other two villages, Danpur and Kesharpur, were only technical in nature, like improper maintenance of case register, wrong reporting of monthly returns, etc. Paragraph. Even as regards village Chandol, of the 1458 cases registered under section 151 bracket 1 of the
15.1. That will be consultation under section 15.1. 151 is there, wrongly typed.
15.1 of the Consolidation Act. What is that full cost title?
OCH and PFL. They have not stated 15.1.
OCH and PFL Act.
Yes. What is the consolidation of voting and fragmentation of
and PFL Act 1972. Only 17 cases had defects, and these have now been rectified. Paragraph. No rejoinder has been filed to contradict any of the above words. The court is satisfied no further directions are called for, the petitions disposed of.
Item number 35.
35 and no instruction, man.
All right, counsel.
I am appealing for sole opposite party.
All right.
Item number 36.
May it please your lordship.
Yes.
Whereas this case is covered by the judgment of the Supreme Court, 259 ITR page 19, that GK and Divens up, and also by your own lordships, by Lord Chief Justice and Justice BP Rautrai, that is also reported case, my lords, that is Videsh Himani versus ITO. Last year, lordship rendered the judgment.
Right.
Another, my lord, sorry. Then another judgment by my Lord Chief Justice and Justice Patnaik. What is it? Yeah. Yes. Well, as the lordship will kindly, now with your lordship's kind permission, I will demonstrate how it is covered. Lordship may kindly see Annexure 3 at page 19. An assessment under section 143(3) was completed on 30th of March 2015. Lordship got it?
Yes.
My lord, page 19. Then, my lords, lordship will straight turn to Annexure 8. Annexure 8, page 29, my lords. There, my lords, the initiation of the reassessment proceeding by issuance of notice under section 148. Then, my lords, I filed a detailed objection, Annexure 8, lordship, page 29. My lords got it? Yes. Then, my lords, I filed a detailed objection, that is Annexure 14 at page 35. My lords, be pleased to see page 35. And in page 36, I have mentioned that this is nothing but change of opinion. So the assessments, reassessment should be dropped. Lordship, I'll take your lordship to page 36. Last para. Under the above facts and circumstances, the present reassessment proceeding under section 147 is based on review of materials submitted at the time of original assessment completed under section 143(3) of the IT Act, and there is no understatement of value, closing stock by so and so, and proceeding initiated on section 147 of the IT Act is not legally permissible and kindly be dropped. Thereafter, my lords, they did not dispose of the objection, straight away proceeded to make the reassessment. I have also annexed the order sheet. Lordship, that is Annexure 15 at page 56. Lordship may be pleased to see page 50, Annexure 15, page 56. There is the whisper that the objection has been disposed of, which my Lord Chief Justice on the last occasion said that this is not a mere quasi-judicial. I have read that Lakshminaran Agency WPC 16139, your lordship have summarized at page 4 of the judgment in paragraph 4. page 4, paragraph 4. The exercise of considering assessee's objection to the reopening of assessment is not a mechanical ritual. It is a quasi-judicial function. The order disposing of the objection should deal with each objection and give proper reason for conclusion. No attempt should be made to add to the reasons for reopening of the assessment. Beyond that has already been disclosed. Now I will take your lordships to the counter affidavit which has been filed to para 6, page 6. Page 6 of the counter affidavit, what they have said. Page 6, para H.
Yes.
For that, the petitioner in the present case has participated in proceeding and filed a returns in response to the notice under section 148 of the IT Act. It is worthwhile to mention here that as per the legal procedure, the opposite part number 1, before issuance of notice under section 148 of the IT Act, the reasons for escape assessment was recorded and the same was communicated to the petitioner as per the request made by the petitioner, and the petitioner responded the same by filing detailed compliance with the fact and figure and requested to drop the proceeding initiated under section 147 of the IT Act. But nowhere the petitioner objected the said notice. Where that objection is to drop the proceeding, what else it is?
So 292 BB is what they're relying on.
292 BB is that once you participate, then you cannot say that the notice. I am not talking of the notice. I am saying that the reassessment proceeding is vitiated because of the fact that you have not. That GK and Ravinsab Supreme Court is very clear that you have to file a return. I have asked for the reasons. You communicated the reasons. I have objected to the reasons.
So that is one part. Then the on merits, what is there?
Merits, my lords, that is either during the course of the assessment also, that is Annexure 3. Thus you will kindly see. Annexure 3 also, I have supplied, there was a notice under section 143.
What are the reasons for reopening?
Beg your pardon?
Reasons for reopening.
Reasons. Yes, reasons has been communicated. Lords will kindly see at page Annexure 11, page 32 and 33.
Right.
That is understatement of the stock. As requested by letter referred to above, the reasons for reopening of the assessment under section 148 of the IT Act for the assessment year is as follows. During the financial
No, so was this based on any material?
No, no material matters. And all these things have been considered in the regular assessment.
Under 143.3.
Beg your pardon?
Under 143.3.
Yes.
All right. Yes.
Is a 143 assessment matters. They will lordship.
All right. Let's ask Mr. Sir. So 2 points. You can come to the second point first.
Lord,
reopening is based only on the accounts.
Only based on the account.
Accounts have been disclosed.
The account has been disclosed, Lord. Your lordship see the order.
Then it's only change of opinion.
No, your lordship see the order. I'm placing Annexure 1.
Same.
It's
just reproducing the whole of that 147. What is this? This is not even, this is even worse now. I've never seen something like this. Whatever is in 147, cut and paste here, and that is assessment order.
That is based.
I mean, this is remarkable. The AO is either in a tearing hurry because the end of the year. What is the date of this order?
Date of the order is
9/11. There must be some target he had fixed for himself.
I cannot develop more, but fact remain these the harp upon that the notice is not within.
See, the biggest disadvantage of computers is this cut and paste.
Maybe, but fact remain, he is harp upon that the notice is not complied within the 4 years. That is the first time.
No, go on the merits now.
My merit in the sense.
What is that escape
my
assessment?
Kindly consider. He has participated in the proceeding.
Right.
And his file compliance.
No. That's why I asked you to come to the second point first. not the first point.
No, correct, no, correct. I understand that. But my submission would be not, Milord, he has participated, rightly or wrongly, assessment has been passed. Admitted, rightly or wrongly.
How is it rightly and wrongly? If it's wrongly passed, it's wrongly.
I may not question, I may not stand on the view, but this is the assessment not has been passed. And I observe the lordship constituent view that appeals should be filed.
Yes.
Even assuming that anything.
We have taken it on board, stayed it for the last 5 years.
Yes, understand, Lord. Your lordship, thereafter also your lordship delegated to file appeal. So thereafter your lordship will see Lord 292 BB.
Right.
And your lordship may consider I cannot develop more. I cannot develop more in this case.
All right. Allowed, we'll pass the detail order.
Yes, your lordship, my submission.
Of course. Argued with great vehemence.
No, sorry. I'm not good. I understand my difficulties.
All right.
Second case, my lords.
Yes.
There I'll support the revenue.
Oh, good.
I want to withdraw this restriction, file an appeal.
All
There
right.
is an interim order. What I favor the interim order to continue.
See, this is what he knows when to leave the ball outside the off stump.
No. I must thank your lordships because of your lordships hard labor. These old matters have been listed. And there are certain large number of income tax appeals pending since 2012. Still are not being listed.
Oh, they're still there.
Still there.
No, so it will come up now.
There is no listing.
Every day putting up
no
50 old
listing.
matters. It will come up. It will come up now.
After I joined, before that, there is not listed, not even admitted. I am searching file and going after the court record and collecting and preparing the file.
Last week, your lordship disposed of the income tax appeal filed in the year 2008, 9.
97 also.
No, it will come
Now
now.
there is
Every
a
day we are
chunk
listing
also.
50 old matters. So it will come up.
Your lordship,
Yes.
I only request your lordship keep it on 5 to 7 matters so that so far as the income tax department appeal. Otherwise, it will be difficult to collect the
He is
file.
gaining well, lords. In any case, he is gaining. All
No.
this tally-
It's not a question of gaining. I have to assist properly. It's not
Yes,
a question
yes.
of gaining or
Correct.
losing anything else.
Yes,
Second
that is
matter,
correct.
you say Mr. Rai seeks leave to withdraw the present petition with liberty to file an appeal
Interim
in
order.
accordance with law if such appeal is filed not later than
4
18
years.
March
Right,
2022, accompanied with an application for condemnation of delay, be considered on merits by the appellate authority. The interim order passed to this court on 8th February 2018 will, subject to the appeal being filed within the time aforementioned, continue till such time the appellate authority passes an interim order on the application to be filed by the petitioner. The court clarifies it is not expressed in even the matter. Petition is disposed.
Obliged.
Right.
Greatly.
Right.
Item 37.
May it please the lordship. My lord, this is the public interest litigation, my lord. And my sole prayer at page 13 is that, my lord, proper maintenance and protection should be given to the ancient monuments located in village Ajodhya in Nilgiri in the district of Baleshwar, my lord. The Honorable Court by order dated 2, my lord, instructed the State Council to file counter and obtain instruction, my lord. As per my instruction, my lord, till today, no protection, no maintenance arrangements are done. And lordship will find the valuable monuments. I have given the photographs, my lord, at page 32 of the brief, my lord.
So what has happened in the last 5 years? This was not listed at all.
Yes.
3 years. So 27 March 2018 was the last effective order. So almost 4 years, 4 years now.
My lords, in the second petition, only original annexer 1 and 2 be returned.
One be
with,
returned, subject
type
to be
of-
substituted with that. address.
Greatly.
All right.
Greatly.
What are your instructions, sir?
Lord, instructions have not come. Lordship may kindly see here the prayer of the petitioner is they belong to a particular village named Ayodhya. There they're saying it is full of monuments and
So
ancient.
somebody should go there and inspect it, sir.
Which needs to be preserved. Here, my
You have
lord,
a state archaeology department or what?
Yes, it
my lord,
is
State Archaeology Department.
OP4.
The Commissioner State Archaeology Office opposite number 4 is directed to immediately visit village
Ayodhya.
Ajodhya, my lord.
Ayodhya, my lord.
Ayodhya in district Baleshwar
Yes.
and
On the
submit to
village
this court
sir.
enclosing photographs, the factual report on the current status of the idols mentioned in the present petition. This report be submitted to the court not later than 7th March
My lord.
2022.
Should I say team constituted by OP4, my lord? Because OP4.
He can, yeah, it will be open to opposite number party number 4 to constitute his own team for that purpose. List on 14th March.
Okay.
Item number 38.
Your lordship. This is a PIL matter, my lord. Matter
This
relates
PIL
to.
has been filed and inaction of the state in disposal of the seized motor vehicles which are lying in the police station.
So it's covered by that other order.
Yes.
My lord,
Alok Ranjan Mohanty case.
That is a different, the facts of this case and that judgment differently only because these materials have been dumped in front on the public road in front of Badambari police station.
Correct. So we'll
That-
ask them to that in this, sir.
My lord.
Wherever it is dumped, it does not have to be in a lockup because even in that petition, they had given photographs of everything lying on the road and blocking the road, even in that petition.
My lord.
So same thing, we'll ask them to implement these directions in this petition.
My
All right.
lord.
We'll keep it, we will not dispose it off. We'll ask them to implement
My
and
lord.
then report to the court.
My lord, that matter will be listed on April, my lord. My lord's direction.
Even here, we're going to not dispose of these petitions. We want to keep monitoring it. We
My
will
lord.
keep monitoring it, sir.
My lord.
You say the directions issued by this court on 31st, the judgment, the directions issued in the judgment dated 31st January 2022 of this court in writ petition civil 31622 of 2021, bracket Ashish Ranjan Mohanty versus State of Orissa, will equally apply in the present petition as well, which complains of a large number of vehicles having accumulated outside. Where, sir? Badambadi.
Badambadi police station.
Badambadi police station.
My lord.
Thereby causing enormous inconvenience to the general public. The Collector Cuttack and the SP Cuttack, is it?
No, DCP.
DCP Cuttack.
DCP Cuttack will file a compliance report in this court on the steps taken by applying the above judgment before the next date. List on 4th April. We'll call it with this.
My lord. There is another petition I have filed along with this writ application in shape of that has been tagged. That is CRPL 1578.
It will come along with this, sir.
My
Let it
lord.
come along with this.
My lord.
It will be listed with this.
Along with that, that will be listed. my lord.
Correct.
Obliged, my lord.
Item number 39.
May I please the lordships, I'm appearing for the state in this matter, I'm on virtual mode, my lords.
All right.
Please.
Pursuant to lordship's direction dated November 25th, my lord, Mr. Vikram Yadav, Principal Secretary, had filed a affidavit. My lord, your lordship had directed him to say that regarding the implementation of food security plan in the state, my lords.
Correct.
He has filed an affidavit. We have served copy on the petitioner, my lord. And
When was it filed, Ms. Patnaik?
my lords,
When was it filed?
it was filed on 4/1/2022, my lord, January 4th. And copy has been served on them.
Right. We've got it. We've got it.
My only little impediment, my lord, is for me is that, my lord, this is the first time that I'm dealing with this matter.
All right. No, but we just want to know the current position because we won't close it yet. Because
Yes, my lord. Current position is, my lord, your lordship in para 7, my lords. Apart from the fact that regarding the 25 left out eligible persons who could not come under the central scheme, my lords,
Yes.
we have a dynamic ration card database is being prepared, my lord.
So you yourself given suggestions? No.
Please, Millets, because the state hadn't come up with any suggestions, so the petitioner, along with few civil society organizations, they sat together who are working in this field. And I have also filed an additional affidavit in the month of January, 6th of January.
Have you seen that affidavit, Ms. Patnaik?
That was also served on the last date.
Yes.
He's filed it on 6th January.
Millets, the state's affidavit, the latest affidavit of the state, where they say that such and such number of ration card management centers are there.
Yes.
That was part of the previous affidavits also. So my impression was that my lords, after seeing all this, still thought that the state should come up with an action plan.
Correct.
Which, my lords, in my respectful submission, is not in this particular
Forthcoming.
affidavit.
So you're asking every sarpanch to now get into the act.
My lord, may I make a submission, my lord? My lord,
Yes.
for proper implementation, my lord, first a database is required, my lord, unless we know the number of beneficiaries. So the implementation will be proper only when you have a detailed, because the ration cards will be issued in 3 categories, my lords. Above the poverty line, below the poverty line, and under you, my lord. 3 kinds of ration cards.
No, but for that you're only responsible, right?
Yes, my lord. So we are working on it, my lord. So we are working on it. Your lordship, my lord, what I'm praying is, your lordship, grant me a short date, because since this is the first time that I'm dealing with the matter, I have not discussed with the officials, my lord. If your lordship will grant me a short time, I'll go through the affidavit filed by the petitioner. I'll have a discussion with them and I'll get back to your lordship.
See, one important factor that the state officials will have to take into account.
Yes, my lords.
Is that Supreme Court has repeatedly said in the last 3-4 occasions, because they are parallelly dealing with this.
Yes, my lords.
They've said merely because you can't link the Aadhaar number with your ration card, you cannot deny rations.
That's
Here we find 19 lakh beneficiaries were kept out of the food security schemes due to non-linkage of Aadhaar. Now, after the Supreme Court directions, this will not hold good.
Well, it's certain guidelines have been also laid down how to include and exclude these beneficiaries.
No, so you can't make it entirely dependent on this Aadhaar linkage.
No, it is not. It is not only Aadhaar based pilots.
No. So I'm just saying you'll have to account for Supreme Court directions also. There are directions issued by the Supreme Court.
Yes, ma'am.
Are you aware of that?
Yes, my lords.
Where is that?
Yes,
My lords, I'll place it.
No, you should have kept it already with USA. How will you help the state council then?
My lords, I'll place it on the next day. My lords, if you see my additional affidavit, my lords, there was a recent survey also conducted in the month of December, after the last order on the 25th of November. And they have also found that was in a couple of villages in Kalahandi district. And they have also found that a lot of these people, now the exclusion is on 2 grounds, my lords. Either you're completely out of it, or you have a ration card.
Ms. Patnaik, there are 2 sources for you to gather that information.
Yes, my lords.
One is the Anganwadi worker, the other is the Asha.
That's right.
Yes,
See, these people actually go door to door. So if you just ask each Asha worker to tell you village-wise which of the villages have ration cards, you can immediately get the data in no time.
Yes, my lord. At ground level.
Yes.
I'll take instructions in this.
Ashwata Patnaik, appearing on behalf of the state government, raised for some time to have a discussion with the officers on preparing an accurate database of ration card holders in the state, so that an action plan could be drawn up for including larger number of beneficiaries under the SFSS scheme in a time-bound manner. There are suggestions made by the petitioner in an additional affidavit dated 6 January 2022, which should also be looked into by the state officials. Full stop. Importantly, orders of the Supreme Court stating that there cannot be denial of rations due to non-linkage of Aadhaar with the ration card should also be taken note of. Counsel of the petitioner undertakes to supply to counsel for the state the recent orders of the Supreme Court in the matter. List on give me the dates of all these PIs. Okay, 8 March. 24th March.
Grateful. Let's just one submission. If they could give their affidavit a week prior to the
Yeah.
date, because
A further affidavit shall be filed with the state officials at least 1 week prior to the next date, with an advance copy to council petition.
Item number 40.
Yes.
Last hearing was on 12th January, but the court was not in session.
Yes, we are taking it up now. Right.
Pursuant to the report submitted by the Commission of Inquiry, we have filed our reply. That is at flag S.
Flag
S.
So let's see the inquiry.
The petitioner has also filed, that is at flag A, flag R, that copy has not been sought to us. Flag S is our reply. In paragraph 2, we have stated with regard to the treatments provided to one Prashant Puruset. May I please?
Yes, please.
Paragraph 3. In reply to para 7, Roman 12, it is submitted that late Prashant Puruset was admitted to isolation ward on 30/8/2020 at 5:20 p.m. with symptom of severe acute respiratory illness for 4 days. Both antigen and RT-PCR test was conducted in the same day, which are negative. He was treated with enoxaparin, hydrocortisone, azithromycin, vitamin C, etc., thinking it to be a case of clinical COVID. He was shifted to central ICU and was also intubated. Assistant Professor Pulmonary Medicine attended him on 3/9/2020 and added.
This is your doctors again trying to defend their actions. This is what else is it? This is what has been examined by the inquiry officer. We have an inquiry officer only so that we'll have an objective assessment. All of this is your version, your doctor's version. We'll reserve orders, so we'll examine the whole thing and pass orders. Orders reserved. Right.
May I submit one thing? On 9th, my lords have reserved the judgment in police matter, acquittal in criminal case, but the discipline. My lord directed to file the written note within a week. Today I am filing them.
All right.
Passport matter. Weekly list passport matter, item number 35.
I'm sorry.
Item 35, WPC 9428 of 2010.
May I pray for short adjournment? I'm appealing for the. A short adjournment for Friday evening.
See, the Honorable Apex Court judgment, Ramesma versus Union of India, paragraph 13, Your Lordship. The principle of no work, no pay. 35, Your Lordship.
There was a whole bunch of matters. So after the weekly Passover, you'll come to supplementary Passover. All right. Yes.
Only some directed that tribunal against the tribunal order came before Lordship. Tribunal is directed. Page 177. Showing that the applicant is found not guilty. So they have direct executive charges and give the that is the direction for reinstatement with all service benefit except financial benefit, for which.
So there's no work, no pay. This is the judgment, Ramesh Kumar.
Yes.
So they have equally some judgments which say the other way around.
Yes, my lord.
Which are those judgments?
My lord, that is 2004, my lord. My lord, friend is there, who will supply me 2004 judgment. That is 2004, volume 1, SCC, page 121 million.
Jaypal Singh. This is personal in both matters.
Here is the case, it is the 2015 lordship, 31st July 2015. My judgment is here.
All right. Here again, we'll reserve orders. Orders reserved.
Yes, one line lordship. Put of duty in 19/1/2000. Order was passed in 2003. 35/2003, wherein that period, put up period, that is the in ED rules, that is the put up, that is like a suspension. Nowhere about stated that the put up period of what has to be done. They have not said so. Only simply, therefore, it is ordered that such and such removed from service to the immediate effect.
All right.
Supplementary list. Pastor matter, item number 1.
My appearance may be noted in item number 35 minutes.
Yes.
My
Item
lord,
number
in
1.
keeping with your lordship's direction, I have already sent a copy through this email and also input land SC and also providing 2 copies. This is reported in 2015, volume 3 SEC, page 404, my lord. I am relying on para 2, 8 and 9. May I place my lord?
No, we'll just take note of it, sir. Wait, what is the other judgment? You have made note of it. Paras 2, 8 and 9.
2, 8 and 9.
All right. Which is your other judgment or only this?
Nothing else. So far, the only condonation of delay is concerned. This is, and so far, the maintainability of this one before this Honorable High Court. So I am relying on a decision of Honorable Apex Court reported in 2020, volume 2, Supreme Court cases, page 442. So, para 14 is relevant. Your Lordship, wherein Honorable Apex Court held that question of jurisdiction is a rule of discretion, not a law of jurisdiction. And in case of Sipai and JCH, it is hardly possible they have cannot afford to approach the Honorable Apex Court, my lord. Okay.
Orders reserved.
Item number 2.
Hello, is it admitted, my lord?
Orders reserved, sir.
Okay. This press admission matter request.
Item number 2.
Press admission matter.
The order has been reserved.
Complement.
None appears dismissed. Not.
Item number 2.
Yes, sir. Item 2. Tell us what it is.
Yes. So what makes the petitioner stand before Lordship is that the petitioner is a member of Orissa Judicial Service, but as of now, she has already attained her superannuation.
There's no point, sir.
No, my lord. In the prayer itself, we have prayed for some financial consequences that can be taken into consideration. In the point number 2 of prayer.
All right.
My lord. The petitioner was
No reply has been filed, Mr. Mudli.
Here he has prayed for giving retrospective promotion to the post of Civil Judge Senior Division.
Right.
And to that extent, she has submitted representation under Annexure 2. And this petition was filed in the year 2014. Thereafter, it was listed 2015 for removal of defects. And the petitioner should apprise the this court as to what steps have been taken in the meantime.
Anyway, you file a reply or you want the representation to be considered?
Yes, your lordship may direct this annexure to if pending, that shall be disposed of.
All right. If the representation dated 1/8/2013. Of the petitioner. Record entry 2 has not yet been disposed of. 2013, yeah. 2/8/2013. It shall be examined by the registrar administration. It shall be examined on the administrative side of the High Court. And a decision thereon shall be conveyed. Reasoned decision thereon shall be conveyed to the petitioner. Not later than 2nd May 2022. If agreed by such decision, will be open to the petitioner to seek appropriate remedies in course.
Item number 10.
Obliged, madam.
May I please, your lordship? In item 10, though I had undertaken to file an application for amendment that has not been filed, but I only beg to draw your lordship's kind attention to page 6 of the writ application, paragraph 4.5 and 4.6. Here, my lord, the vending zone was installed over a drain by the side of the SCB Medical College. That is what is the grievance is. Application was made before the BDA authority and pursuant to which they have conducted an inquiry. That is what I have stated in paragraph 4.6. May I only pray, subject to your lordship's kind consideration, this action may be completed within a time-bound period, because my instruction today, I was taking instruction, is that a case has been registered by the CDA authority, but that has not been disposed of.
All right. Who's for the CDA?
Normally, my name Mr. Dayanand Mahapatra appears for CDA.
Where is he now? It's always better to have those counsel present. Mr. Dayanand, the registry will inform Mr. Dayanand Mahapatra. Counsel normally appears for Cuttack Development Authority to remain present to the next date. This on 21st March.
Obliged.
Item number 12. 12 to 18.
None appears.
Item number 12, my lord. Item number 12 to 18, my lord, these matters relate to challenging the virus of amended rules of 2016 and 20, my lord. My lord, let it come after a week, my lord, after removal of defects, my lord.
No. Tell us what it is about, sir.
My lord, I have challenged annexure, my lord. Your lordship may see page number 46 is started, my lord. That is 2016 rules, my lord. 2016 rules as well as the 2020 rules, my lord. That is under annexure 5, 4 and 5. My lord, with a direction to give appointment the petitioner under 1990 rules, under which rule his father died, my lord. My lord, his father died in under the rule.
But you are already covered by judgments of the Supreme Court, sir.
Yes, my lord. Yes, my lord. That is, my lord, only thing may be added that these rules may be quashed and with a direction to give appointment.
Not straight away. It's the other way around. It's the other way around.
Madam?
It's the other way around.
My
Those
lord,
decisions are against you.
My lord, I have challenged these two rules, my lord. My lord, the 16 rules.
Decisions of the Supreme Court are against you, sir. Are you
My
aware?
lord, yes, my lord, that is Ashish Kumar Asusti case, my lord, in single bench. Honorable Supreme Court already passed order, my lord, regarding that, regarding in favor of the petitioner, that whose father died, my lord, in the prevalent year of 1990, his son will, my lord, get appointment under reallocation scheme appointment.
No, it's the other way around, sir. It's the other way around. The
Yes,
Supreme Court judgments are against you. Are you aware?
Yes, my lord, let it come week after, my lord, after removal of
Are you aware of the division bench order of this court?
No, my lord. My lord, let it come after a week, my lord.
Then I will place
Defects
after
we
removal of
removed
defect, madam.
Yeah, defects we removed within 2 weeks. Just thereafter. Before the roster, which because the service matter, the appropriate bench it has to go. At appropriate bench, just before the appropriate bench thereafter.
Item number 23.
May I please, Your Lordship? My lord.
Item 12 to 15, my lord.
Numerous defects, sir.
My lord,
Numerous
this is a
defects.
PIL matter wherein
Sir,
the
numerous
Musafir Khana has been
defects.
constructed. Yes, my lord.
Please remove the defects.
It will be taken up next week, my lord.
First, you remove the defects, sir, then it will be taken up.
Yes, my lord.
May I make a small prayer, my lord? May I make a small prayer? Item 37 of the supplemental list. Lordship, this is that matter, Lordship directed the Archaeological Survey to make a inquiry and submit a report, my lord. That Ancient Monument Act, my lord.
Correct.
Yes, here I'm only praying, my lord, because of the ensuing Panchayat election, my lord, 2 weeks time, everything will be, I just need more time. And Lordship has kept it in the first week of
This
March.
Commissioner of Archaeology will not go into elections,
So
sir.
he'll be needing the local assistance of the authorities, my lord. I was only praying a little longer time, my lord.
Actually, that window is okay. Say submit a report by 14th, you say. And list on 21st.
Bless.
All right.